So welcome in Munich to our Café Datenschutz today with a very special guest from Tel Aviv. Dan, it's such a pleasure having you here. Welcome to Munich.
Thank you, Sebastian. Thank you for having me here.
So for those who don't know you, your name is Dan Or-Hof. You're founder of Orhof Law and you're founder of ClearPath. You're holder of the Vanguard Award, Westin Fellow recognition, and you're the founder of the KNet, of the IPP Knowledge Net in Tel Aviv. So you're Mr. Privacy in Israel then?
Well, I'm not the only privacy practitioner in Israel, but I'm doing that for quite a long time, yes.
Perfect. Yeah. So it's great to have you here. We're in a partnership alliance, Strand Alliance, and I just wanted to take the opportunity of your visit to Munich and talk a little bit about the development in the privacy scene and the privacy legislation in Israel and what we might want to learn from that also with the ongoing development here in Europe with potentially updating GDPR. So what's happening in privacy legislation in Israel and what has happened this year?
Well, the major issue that happened just recently in mid-August was the enactment of a new amendment to the protection of privacy law in Israel, what's called the Amendment number 13. And that's a major reform, I think, in many cases, in many areas of the law, in many aspects of the law. But I would maybe focus on maybe three of them. One would be the sort of redefining some basic definitions under the law. So personal data, what would be sensitive personal information, for example. The other would be the mandatory appointment of DPOs. That's mandatory now under Israeli privacy laws as well. And the third aspect, which is probably the most deterring aspect of the amendment, is the enforcement powers that are now granted to the Protection of Privacy Authority here in Israel. They have a lot of enforcement powers on their hand, including the ability to impose very hefty fines and some other substantial powers. So this is a major change in privacy laws in Israel.
So let us talk through this step by step. So from a constitutional level, how is privacy being defined or recognized in Israel?
Yeah, well, we have a sort of a constitution, which are called basic laws. So one of these basic laws that govern the human dignity and liberty enshrines the right to privacy as a sort of a constitutional right alongside other individuals' rights. So yes, that's a sort of a constitutional right.
Constitutional level, and then there's a national privacy law. You call it protection of privacy law.
Exactly.
That's easy to remember.
Very easy. Yeah. Protection of privacy law. It was actually one of the first privacy omnibus worldwide. It was enacted in 1981. But ever since, there weren't so many changes and amendments to it. So the last amendment was a real change.
And complete overhaul and update on some of the regulations.
It was an overhaul. I wouldn't say complete. Okay. There's still work to be done. But yeah, it was a major change.
So let's start with the topic of DPO. You mentioned that DPOs were made now mandatory in certain circumstances. Under which requirements do I have to appoint a DPO under the new privacy law?
So most of the requirements are very similar to those that probably the audience is familiar with under the GDPR. If you process, sensitive information on a large scale, or you conduct, systematic monitoring over individuals, then these would be triggers to appoint a DPO. If you are what the PPL, the Protection of Privacy Law, calls a public body, a government ministry, municipality, statutory organizations, etc., these have to appoint a DPO as well. What's different is that data brokers need to appoint a DPO as well. So that's another mandatory requirement.
And then the DPO has, I guess, similar tasks like the ones we are used to under GDPR, training of employees maybe, and contact point for data privacy authorities, all matters privacy, I guess. Is there also some sort of audit or oversight functionality with the DPO?
Yeah, so there's to some extent it's very similar to what we're familiar with under the GDPR, but there are some additional requirements, for example, to create and to perform an oversight plan, usually on an annual basis. And to oversight the cybersecurity function in the organization, especially around the information security procedures of the company. This is quite different from the GDPR. Essentially the protection of privacy law and privacy laws in Israel in general very much focused on cybersecurity, more than what you're familiar with under GDPR. And they apply to everyone. They apply to public bodies alongside all the private market as well. So the DPO is very much involved in information security aspect, the actual information security aspects as well. And this is part of the statutory requirements from the DPO in order to function. Yeah.
Okay, so we have the protection of privacy law then, and then we have different regulations that the different ministries can issue. Could you explain this a little bit more?
Yeah, when we talk about privacy regulations, so essentially the protection of privacy law is a sort of that's a parliamentary instrument. It was enacted by the Knesset, the Israeli parliament, and then the protection of privacy law provided an authorization to the Justice Department to issue regulations under the protection of privacy law on specific matters. So you have a few sets of regulations that relates to data security, data transfer, exercise of rights, data transfer and sharing between public bodies, and other matters that are essentially indicated and detailed in the regulations rather than in the law itself.
Could you explain a bit in more detail on the topics around information security and the deriving regulation? Because I think that is of particular interest, because I think there's some combination with ISO standards or industry standards. Could you elaborate on that one?
Yeah, I think that's something which is fairly unique, I think, in terms of legislation, because I assume that what you're familiar with in terms of information security requirements would be segmental, industry-related, specific, like NIST and NIST2, for example, or HIPAA in the US. But in this case, the Justice Department in Israel has enacted data security regulations under the protection of privacy law that apply to everyone. And the baseline of the requirements are very similar to what cybersecurity professionals are familiar with under information security standards, such as the ISO 27001. So there's very much of similarity between the standard and the requirements under the regulations. And I think, and the local regulator in Israel, the Protection of Privacy Authority, has even gone one step further and published guidelines under which, if you are ISO 27001 certified, then you are presumed to be compliant with a great deal of the data security regulations. Not all of them. There are still some specific provisions that you must need to make sure that you comply with them as well. But the large majority are presumed to be to be in compliance with if you are certified. And that's another sort of a way to show the very strong synergy between privacy protection and information security in terms of privacy legislation and regulation in Israel.
I think which is a direction that maybe also GDPR should be moving to, so to combine more information security aspects and maybe also use ISO similar standards more in order to establish guidance that companies can actually use to adhere to.
Absolutely. I think that it's probably a must. And I think that, companies witness it, especially when they're hit with cyber attacks. And then I think that in these types of circumstances, they do realize how connected are these worlds. And that means that, the DPO must know DPOs must know their ways with information security. That's essentially part of the job description. The DPO under the PPL, under the Israeli law, needs to understand information security, not just be knowledgeable in privacy laws and regulations. That's part of the job description. You need to know your way with it. And I think that yes, I think that this is a real risk that companies are facing all the time, and these risks are only getting higher all the time. And I think that regulation, by definition, needs to be a sort of an instrument that would provide actual good guidance to companies of what to do and how to do it. And when you stick only with sort of general 30,000 feet type of principles, that's probably not enough.
Yeah, you're not ending anywhere at the end of the day. Can we have a look at the concept of legal basis? Because this is under lots of criticism also currently with GDPR. Maybe it's too narrow, maybe it limits companies too much. How is this addressed in the new update?
So there wasn't any change in terms of lawful ground of processing. There is some thoughts by the Justice Department to introduce additional lawful grounds of processing in future amendments to the law, but that's not something that was part of the recent amendment. So we're essentially stuck with consent. Or with statutory authority to violate or to harm privacy. But without a statutory authorization, you must have a consent, and consent should be informed. It could be. It doesn't necessarily need to be explicit. It could be implied through behavior, but it needs to be informed. It needs to be freely given. That's under guidelines of the PPA, the Privacy Protection Authority. So it's pretty onerous to maintain a situation where you've secured an actual lawful consent, but that's the only way that you can process personal information without violation of the law.
So there's a certain similarity with the strict and narrow interpretation of the European Court of Justice under GDPR. Very little room for contractual required, very little room for a legitimate interest. So we all going to end up using consent then as
pretty much
basis?
Yeah, pretty much. And I think that's probably not the best way to move forward because it puts all the burden on the individuals. I think.
Okay, but it's interesting to see sort of the focus on information security, and maybe that's something Europe can learn from that approach to sort of integrate this approach more deeply also in the current GDPR discussions and Omnibus discussions on updating GDPR.
Absolutely. I think that, part of our practice is to sort of look at the synergy between privacy, cybersecurity, and now AI, and potentially other data-related regulations, data governance regulations that apply to the use and the processing of personal data in various use cases and circumstances. They are all synergetic, and that calls for a sort of a more robust, more holistic approach to all of these requirements, all of these aspects together.
Yeah, you're not only admitted to the bar in Israel, right? You're also admitted to the bar in New York. So sort of you oversee also the US development in that regard. You're also the founder of ClearPath. Could you elaborate on what services ClearPath is providing and maybe how SMEs in Europe could make use of the services that ClearPath is providing?
Yeah, sure. So ClearPath essentially follows this type of reasoning, the understanding that we need to look at data governance in the broader perspective. And that means that companies need a sort of a one-stop shop, an end-to-end type of service provision in relation to data governance, which will include DPO services and other compliance work that companies need in relation to personal data. They will need information security services. They will need the CISO. They will need incident response teams. They will need those service providers that would conduct their penetration tests or to negotiate a ransomware attack. And they will need those AI professionals to support them with responsible development and use of AI. And this is all synergetic. And I think that we've come up with the idea basically from requests by clients. Clients approach us and asked us about additional types of services which are in sort of in the vicinity of our practice, and that led us to the understanding that the companies would benefit from sort of a service provider that will provide them a whole array of services, and this is what we do. So we provide privacy compliance, we provide AI compliance, we provide cybersecurity support as well. Excellent.
So we're linking the website down below in the description. Dan, again, thank you very much for your visit and for sharing the latest news on the developments in Israel here. And yeah, enjoy your time here in Munich.
Thank you very much, Sebastian. Happy to be here. Thank you for the interview. Had a great time. Thanks.
Thank you.
Thanks.